Good morning, everybody. Thank you very much for being here. My name is Cynthia Lum. I'm the director for the Center for Evidence-Based Crime Policy at George Mason University. I just wanted to take a very short time this morning to extend a very warm welcome to all of you this morning on behalf of myself and also Professor David Weisberg, who is our executive director of the center. I am very pleased to announce that today we have 8 of the top researchers on pretrial justice here with us to present to you what we know and also what we need to know in the future about pretrial justice.
In the mid-1960s, a New York City businessman by the name of Louis Schweitzer had occasion to visit the detention center in New York City, and he realized, upon having seen what he did, that vast numbers of people were being held awaiting trial who could safely be released. This led and caused him to found the Vera Foundation, which he named in honor of his late wife. He funded it, and that was the beginning of what commonly is referred to as the bail reform movement. That movement continues apace. Its objectives and the objectives of organizations like the Pretrial Justice Institute are far from being fully accomplished, both at the federal level and at the state level, despite the fact that we have the Bail Reform Act, which Congress enacted shortly after this movement got underway, and certainly within the states, there's also much to do. I hope at the end of the day you'll come to agree with us that research is important, it counts, more of it needs to be done, so that legislators, not just congressmen, but those at every level in our country, come to understand that reform is possible and why and how it can be accomplished.
In any given year, we all have like a 3% chance of reporting a crime to the police. That means 97% of us don't. 3,200 sounds big. When you put it in that context, crime has dropped, and it's something, thankfully, that's not affecting most of us in our daily lives. The other statistic I just want to note for you here is that if you do a horizontal line to where we are now, we're at a crime rate that existed about 1970. Okay, so, and it just so happens in 1970, we had a jail population of about 178,000 people. Today, it's over 700,000 people. We had an incarceration rate of 80 per 100,000 back in 1978. Today, it's 220 per 100,000. So it's not the crime issue that's keeping our population up at this point.
It was once said that pretrial decisions determine mostly everything. What I find most fascinating about that is that it was said by Professor Caleb Foote when he was studying the issue of pretrial release and detention, but he said it in 1956. In the nearly 60 years since Professor Foote drew this conclusion, research has shown that release and detention impacts the disposition of the case, the likelihood of being incarcerated, and the length of incarceration, and public safety in both the short and long term. Only about 10% of jurisdictions use any research-based objective tool to help identify the risk to public safety and failure to appear in court. A majority of jurisdictions have limited or no supervision or services to mitigate risk. Release or detention is often determined by a defendant's resources, being their financial resources, not the risk that they pose to the public or to failing to appear in court. The result of that is high-risk defendants are released and low-risk defendants are detained.
And so when we don't have a tool in place, when we don't have an objective actuarial risk-based tool in place, we see that it leads to the potential of bias in decision-making. It leads to the over-reliance on bail, which was discussed briefly earlier, and it leads to increases in jail expenditures. Jails are expensive to run. Those folks that are released, when people think of release, they immediately think, oh my gosh, they're not under supervision, there's no accountability, and that's simply not the case. People can be released under supervision. People can be released with different types of restrictions. People can be released, especially with the advent of a lot of the technology when it comes to GPS tracking and things of that nature. It's not a matter of just releasing straight up.
The risk principle applying in pretrial services. Okay, so lower risk cases, if we do stuff to them, put conditions on them, they fail at a higher rate. The higher risk folks, though, when we place those conditions on them, they do better. So we know what to do. We just need to do it to the right people. And we need to spend less money on locking people up pretrial. It violates, you know, our own rules, our own laws, our own sense of justice. These people have not been convicted. Some of them never are.
But we try to focus on the root cause of the problems. I mean, some of the things that you can focus on might be symptoms like not having a job, but really the reason might be something deeper like, well, not having job skills or cognitive deficits or poor problem-solving skills. So those are the things that we try to address with our interventions.
Prosecutor-led diversion programs have been part of the legal landscape since like the 1970s, and they've been studied extensively, especially in the 1970s. The problem is that although the research was rigorous, methodologically sound, there was no, there was no true conclusion on whether or not these programs work. And part of the reason is because the programs are completely different in jurisdictions all over the place. What we found was that reducing recidivism is not a commonly stated goal, which is fantastic. It's more things like reducing the collateral consequences, providing treatment to address the underlying causes of crime, and to save money, use resources more efficiently. A lot of the times people would say, we want to provide treatment to address the underlying causes of crime so that they won't reoffend. So recidivism was kind of implicit, explicit oftentimes, but really they were trying to deal with these other goals on the forefront.
I should point out that the New York City Criminal Justice Agency is a direct descendant of the original Vera Institute bail reform project. I make that point because it means that we and the criminal courts in the city of New York have had well over 40 years of experience dealing with this issue of release on recognizance and dealing with risk assessment-based recommendations to the court. I think that's important because in many instances, I think we are fundamentally dealing with court cultures that take a long time to develop and an equally long time to change. And so the information I will give you now about New York City should be understood in that context. I've been about the business a long time. CJA's research sought to determine whether the fact of a defendant being detained influenced the likelihood of conviction, and if conviction, the likelihood of an incarcerative sentence. You've heard earlier research which pursued the same issue, and we came to essentially the same conclusion. We found that detention definitely increased the likelihood of conviction and the likelihood of incarceration after a range of other factors such as the seriousness of the charge and the defendant's criminal history were taken into consideration. Importantly, we noted as well that the effect was stronger in felony cases than in misdemeanor cases. So if nothing else, that adds to the growing amount of research that indicates that what happens pre-trial affects almost everything. We also found that where bail bondsmen were involved, they tended to be involved in the high bail amount cases because that's where the profit can be made. And they were rarely, if ever, participants in cases in which the bail amount was set at $1,000 or less. So, at least in New York City, bail bondsmen are of no help whatsoever to poor people who are being held on low bails and often on low severity charges.
And really, that the cost of detention is an important place to start. That's likely going to be the most expensive part of the pretrial decision, is keeping people in jail longer and those expensive jail bed days that are used. But there are also other pieces that are very important to estimate. So what is the value of avoiding crime or avoiding failure to appear? How can we monetize that? And then there are now methods to do that, and those are being done. Vera Institute has talked about how to do that through their cost-benefit knowledge bank and the results first work, as well as some of the work that I'm doing with CJI. There's also the ability to use this to measure some of the other potential impacts of the pretrial system. So looking at things like recidivism reduction. So if individuals are released early and they're less likely to recidivate, we can monetize that. Or if we look at individuals that are released pretrial and they're less likely to serve longer jail sentences and longer prison sentences, again, we can monetize those things. But as of today, I haven't seen any research that has done that. So this is a new area that needs to be examined. Now, I think this was mentioned earlier, that when we're looking at non-risk-based systems where it's based on your ability to come up with cash to get out of jail, it usually doesn't matter what the risk level is. So we're getting two suboptimal outcomes. One is some of these high-risk individuals can get out of jail because they can afford to. They're causing more damage than the cost of them staying in jail. And then we have a lot of these low-risk individuals who don't get out of jail because they can't afford it. And that's also suboptimal because it's costing the system more than the damage that we'd expect them to cause upon release.